Live discussing a current event from the legal perspective and answering your questions in the chat every weekday afternoon. Remember that it's not legal advice. You can only get legal advice by consulting with a lawyer one-on-one, sharing the facts and circumstances of your case, and then getting that direct feedback from the lawyer. That's legal advice. What we discuss on this channel, it's general in nature only. It's entertainment. It's educational. It's meant to broaden your perspective, but it's not legal advice. With that said, let's get into the current event for today, which is a new law that was just passed in California, signed in by Governor Newsom, AB 2188, Discrimination in Employment Use of Cannabis. That's right. There is a new law that prohibits California employers from discriminating against employees for using cannabis. But does that mean that you can be high on the job? No, it does not. Visible signs of impairment can still get you fired, but if your employer just decides to drug test you randomly and you test positive for not tetrahydrocannabinol, which is THC, that's the chemical compound in cannabis that can indicate impairment and cause psychoactive effects, but tetrahydrocannabinol is then metabolized and stored in the body as a non-psychoactive cannabis metabolite. And that's what's detected in the urine tests and in the hair tests that your employer might give you if they decide to drug test you. You can test positive for that in California after January 1st, 2024, and your employer cannot discriminate against you for having it in your system. However, there are exceptions to this. The law specifically exempts employers and employees that are hired for positions that require a federal government background investigation or security clearance. It also does not apply to an employee in the building and construction trades. And finally, if the employer is working a government or federal contract that requires applicants or employees to be tested for controlled substances, that federal contractor can still discriminate against you if you have cannabinoids in your system. I guess these are the non-psychoactive metabolites of cannabis that THC converts into that are detected in the urine tests. So this is a big, huge thing because a lot of employees get drug tested. They get drug tested and then they get terminated for having cannabis metabolites, non-psychoactive ones in their system, which indicates that they may be tested positive for cannabis use that was 3 weeks old or 2 weeks old or a week old, not current impairment. So the current drug tests that exist do not test for impairment. They only test for non-psychoactive cannabis metabolites, and that is prohibited by this new law, AB 2188, with the caveat that it doesn't go into effect until January 1st, 2024, and it excludes employees in the building and construction trades. It excludes employees that are hired for positions that require a federal government background investigation, and also those employers who are getting contracts from the federal government, and those contracts then require, because remember people, any type of use of cannabis or that includes THC, we're not talking about CBD, we're talking about the psychoactive tetrahydrocannabinol, THC. Any detection of that is prohibited under federal law. It's still a controlled substance, even though it's legal under California law. So I'm just looking at this bill, the actual text of it, and that's where I'm getting my information from. So this is coming right from the California law that has been amended to include a prohibition of employers discriminating against people who are employees who test positive for cannabis, because the current methods, the urine tests, the hair follicle tests, those do not measure current impairment. They only measure the non-psychoactive cannabis metabolite, which can stay in the system for several weeks. So this has huge implications because marijuana, THC, cannabis is legal in California. It's sold all across the state. There's a lot of people who use it, and who are not impaired on the job, but use it maybe instead of alcohol, which is shown to be a much more damaging drug. Certainly all drugs should be avoided. I think that I'm not advocating for the use of cannabis, but I'm saying if you do use it after 2024 and you don't work in the construction or building industry, and you don't work for an employer that gets federal contracts or that requires federal security clearance, you're going to be safe from testing positive. Now, what context could this apply to? Here's the legal perspective. In my practice, I represent a lot of California workers who get injured at work. And one of the things that happens to California workers when they're injured on the job is they're immediately sent for a drug test. And if they test positive for a cannabis metabolite, which is a non-psychoactive component, a breakdown of THC that does not test the current impairment of the employee, the employee can be fired, and then they lose out on a bunch of their benefits under workers' comp. That's going to no longer be the case after January 1st, 2024. So if you're an employee out there and you're using cannabis, but you're not impaired on the job and you get hurt at work, your employer can, at this moment, send you to the industrial medical clinic. In addition to providing you with medical treatment, they can also test you for the use of cannabis. And if you test positive, you can be terminated under the company policy, even if you were not impaired when you were injured. It's a big deal, people. I see it all the time. I see it every month. I see one of my clients who comes to my office, says I've been injured, I need help, and then boom, they're sent to the industrial medical clinic. Boom, they're sent to get a drug test, and then boom, they're terminated. And even though they can't work because of their injury, the employer tells the insurance carrier that they could provide the injured employee with modified work, but for the fact that the employee lost their job due to a good faith personnel action of terminating that employee for the use of cannabis. That happens. That's real, people. And a lot of employees are using cannabis, and we now have protection. What about law enforcement? Well, according to this statute, law enforcement, that's a good point. Does law enforcement, do people who drive and operate transportation like truckers? No. According to this law enforcement is not accepted from that. So if you're out there and you're a cop, you can go ahead and use cannabis, it looks like. Truck driving, no. Thanks, Charlie, for that question too. No, you don't get in trouble. You can't be discriminated against if you're driving a truck. I don't know why that's not included, transportation, because it seems to me those jobs come with inherent risks, just like building and construction trades. But that's the law. That's the law that Governor Newsom signed and has been enacted, but it doesn't come into effect until January 1st, 2024. That says it right down here. Right here. This section shall become operative on January 1st, 2024. So if you're out there and you do use cannabis and you get hurt at work, you could lose your temporary disability benefits if you test positive and your employer terminates you. But soon, you will be protected. Well, this is Alexander Napolin, Attorney at Large Goes Live every weekday, discussing a current event from the legal perspective and answering your questions in the chat. Charlie, thank you for those questions. I really appreciate it. I love answering your questions and going over these things because I think it's important that everybody out there has an understanding of their legal rights, especially California injured workers who I care very much about protecting. Anyway, that's all for now. Remember, it's not legal advice. If you need legal advice, you need to call my office, dial 866-NAPOLIN, request a free and confidential case evaluation, or go ahead and send me a message at my website, www.napolinlaw.com. For now, I'm signing off. I'll see you all tomorrow afternoon for another current event from the legal perspective and answering your questions in the chat. Remember, www.napolinlaw.com, or you can reach me at 866-NAPOLIN.